So before everyone gets that YouTube link quickly, I just want to make sure if all the judges are here. So I'm just going to read out your name. And just
you can put it in gallery and take a look.
That's really difficult for me to do right now because I have a million tabs open. I'm just going to ask the judges to call out. Paul, are you here?
He's here.
Thank you. Caitlyn Kasper?
Not here yet.
Not here yet. Okay. Oh, there she is. Okay, great. So we've got Caitlyn Kasper on. Okay, great. Naomi Sayers.
She's here.
Okay,
yes.
Mark Underhill.
I'm here.
Adam Goodman.
Here.
Jordana Goldless.
Here.
Andres Hannah Flores.
Here.
Omar Haredai.
Present.
Carrie Lynn Barkley.
Here.
Great. Monis is going to, I'm going to hit record. The live stream, I believe, has already been sent out and people are streaming it, I'm sure. We're all going to be muted. The only judges can remain unmuted to ask questions. Competitors stay muted unless you're making submissions. And Monis will unmute himself to do introductory statements, remarks, and to call time, so on and so forth. Okay, I'm going to now hit the record button.
Is it being recorded? All right, everyone, welcome to the final round. Congratulations to the competitors for making it here. And a special thanks to all the judges for taking their precious time out to judge our competitors today. So the round will be 15-minute rounds per individual. I'll put up the time signals at the 3-minute mark, the 1-minute mark, and I'll say time. There's no additional time granted. If judges permit, we have an additional 10 to 20 seconds, but no more than that. I don't know who the Chief Justice of the room is. Jen? Oh, okay, it's Paul Williams, okay. So I will put myself on mute here, and the justices, you're more than welcome to take it away from here.
Pardon me, should we rename ourselves with our numbers again for this round?
Yes, please. As long as everyone's ready, the appellant can come up and the justices can tell you when to start.
May I proceed, justices?
Go for it. Sure. Thank you.
Thank you, justices. My name is Navya Sheth, and I am here with my colleague, Lesha Shah, on behalf of the appellant, Her Majesty the Queen in right of British Columbia in the case at bar. Would the court require a brief summary of the facts?
We're okay. Thank you. Please go ahead.
It is the appellant's position that the Supreme Court of Canada erred in finding that Mr. Desautel is a member of the Aboriginal Peoples of Canada with a right to hunt under Section 35 of the Constitution Act of 1982. We posit that the core issue in the case at bar is the meaning of reconciliation in relation to Section 35, and that true reconciliation requires that Indigenous and non-Indigenous members of Canadian society be equal partners in the creation of a new shared sovereignty. To this end, the appellant has two submissions to make today. The first submission, which I will address, is that a purpose of interpretation of Section 35 extends protection only to those Aboriginal peoples who are located within Canada today. Our second submission is that should this court find that the Lakes Tribe is a member of the Aboriginal Peoples of Canada, There is still insufficient evidence to demonstrate that Mr. Desautel can have a Section 35 right to hunt. In light of these two submissions, we respectfully request that the Supreme Court of Lions Cup allow this appeal, uphold Sections 11(1) and 47A of the Wildlife Act as they pertain to the respondent, enter a verdict of guilty, and remit this matter to trial court for sentencing. To begin with the first submission, the majority and the dissent of the Supreme Court of Canada agreed that the question of whether Mr. Desautel is a member of the Aboriginal peoples of Canada is a separate threshold question which must be answered before the court can proceed to the Vanderpeet analysis. It is the appellant's position that on a purposive interpretation of Section 35, this question must be answered in the negative. In the 1985 case of the Queen and Big M Drug Mart, the court set out 3 factors which must be considered in a contextual analysis of any constitutional provision. These 3 factors are linguistic, philosophic, and historical. It is our position that the Supreme Court of Canada's majority erred in not conducting this contextual analysis. And in conducting the analysis, the court will arrive at the conclusion that Mr. Desautel is not eligible to be a member of the Aboriginal peoples of Canada. The linguistic context implies a connection to modern Canadian society. The 2015 case of Karen in Alberta tells us that constitutional interpretation must begin with the language of the provision in question, and that any interpretation cannot undermine the primacy of the written text of the Constitution. And as the written text of the Constitution plainly includes the geographical modifier of Canada, there is a limitation on who may be considered a member of the Aboriginal peoples of Canada. Of Canada is used consistently throughout the Constitution as a geographical modifier, and the presumption of consistent expression indicates that it should be read in the same manner in Section 35 as it is read elsewhere in the Constitution.
But if I may interrupt there, is it used consistently? The citizenship requirement in Constitution Act 1982 for voting and mobility rights indicates citizen of Canada, but you can be a citizen of Canada without ever having stepped foot in Canada. So it's not really geographical, it's really more about ancestry at that point.
Justice, respectfully, it is not about ancestry. Citizens of Canada still implies a link to the existence of, or a link to modern Canada as it exists today. As citizens of Canada hold an ongoing status as participants in Canadian society, even if they do not live here.
Counsel.
Yes, Justice.
So, but for Aboriginal communities, they're also citizens of their own community, and you're suggesting that Canada's, in that line of thinking, Canada's citizenship takes precedence.
Absolutely not, Justice. We acknowledge that Aboriginal peoples of Canada are citizens of their own communities, and that they have a unique form of dual citizenship in a way with their Canadian citizenship. It is merely the case that as Canadian citizenship pertains directly to the responsibilities of Canadian government, and that Aboriginal peoples of Canada must have a link to the land. And I'd like to clarify here that we are not asking for a citizenship requirement on Aboriginal peoples of Canada, but rather that they be members of or participants in Canadian society in some way, shape, or form. And
But to a certain degree, doesn't that kind of beg the question insofar as if they are not permitted to assert these rights geographically in British Columbia by this court, by implication, then they won't be able to form a part of Canadian society and contribute to Canadian society. So isn't it ultimately begging the question, to put it that way?
Justice, I understand your concern. However, I'd like to refer now to some of the philosophic context of the provision in the Supreme Court of Canada's jurisprudence, which indicates that a proper reading of the provision does limit it to those people who are in Canada. And I understand that it is this court's job to determine who constitutes a member of the Aboriginal peoples of Canada, but it's our position that that has actually been established in past jurisprudence as of today. And so it is not begging the question to ask this court to make this determination. In fact, in the case of Beckman and Little Salmon Carmack.
So counsel, I just want to make this clear. Your position is that Mr. Desautel's status as being a successor and a descendant of the former tribe who lived in British Columbia does not count as close enough in terms of connection or descendant in terms of citizenship?
Respectfully, Justice, there are a multitude of factors that point to Mr. Desautel being far enough removed to not qualify. The Sinaites peoples have not practiced their traditional round since 1930. They've been extinct in Canada since 1956. And Mr. Desautel himself is a permanent resident in Washington State. And
is that their fault though, counsel? We know that the evidence suggests that there were various acts that caused them to, as you say, become extinct in Canada. Is that not a factor here, or when we apply this test?
Yes, Justice, it may be a factor at the level of continuity, but it is our position that at the level of a threshold question, the real question before the court is to whom can this law apply as a function of our Constitution? And if we do look at the court's jurisprudence on this matter, it does point to the fact that although the honor of the crown looks back, it also must look forward to the creation of that mutually respectful long-term relationship that was referred to in Beckman. And this was elaborated on in the case of Mitchell, citing the Royal Commission on Aboriginal Peoples, where Justice Binney explained that the goal of reconciliation is the creation of this new merged sovereignty in which Aboriginal and non-Aboriginal peoples of Canada, that is non-Aboriginal and Aboriginal Canadians, are part of a new shared sovereignty, which is built together.
Excuse me, counsel, is not the purpose of reconciliation also to try and acknowledge and right the wrongs that have been done to Indigenous people through the process of colonization? And would that not include the recognition of those Indigenous groups who were forced out of their traditional territories, whether or not it was at gunpoint or they were coerced? I would definitely think reconciliation would need to take that into account.
Absolutely, Justice. Reconciliation requires the understanding of the Aboriginal perspective. You are correct. But in considering the Aboriginal perspective, the common law legal system is, as was said at Vanderpee at paragraph 49, limited because it must do so in terms which are cognizable to a non-Aboriginal legal system. And it is our position that our friends' submissions today, which ignore the existence of national borders, which are in fact the very foundations of national sovereignty, would be to undermine the terms on which the common law legal system is founded, and therefore are fundamentally not cognizable to a non-Aboriginal legal system.
Counsel, is there a reasonable hypothetical out there that an Indigenous person that is not in Canada can get these protections, or is it essentially your argument that Section 35(1) would never allow that?
Justice, in the case of the Mohawk, for example, they are a community that lives across the border between the USA and Canada, and they are acknowledged by both governments, and they are participants in both American and Canadian society. So it is our position that groups such as that, which do exert a presence on both sides of the border, can claim Section 35 rights. However, the unique position of the Sinaites and Mr. Desautel does restrict him from being an Aboriginal peoples of Canada because, unfortunately, beyond the connection in the minds of the people, there is no presence of the Sinaites north of the border and has not been for many, many decades.
But the function of colonialism, like their removal from Canada, whether it's forceful or not, was very much a function of a disruption of their use of the land. And so if this is really about reconciliation, Section 35, shouldn't we use a more flexible approach towards the claimant's perspectives here?
Yes, Justice, there must be a more flexible approach taken in general in the case of Aboriginal rights. But this more flexible approach, if I could quote the case of the Queen and Marshall, that generous rules of interpretation should not be confused with a vague sense of after-the-fact largesse. And therefore, there's only so far that generosity may extend. And in this case—
Sorry, counsel, let's make this real, not just quoting the cases. How is this largesse? This is one single shot done for a ceremonial purpose. This is not a slippery slope. This is not opening up the floodgates. This is a single hunting expedition for ceremonial purposes. And why can we not allow that? Canada is not going to fall apart over this.
Respectfully, Justice, although we would shrink back from characterizing it as a slippery slope argument, the decision of the court today that does allow Mr. Desautel to be considered a member of the Aboriginal peoples of Canada does then open the gates for Aboriginal peoples who do not live in Canada and have not lived in Canada for many years to be protected under Section 35. And in particular, we're concerned about the policy implications of the potential title claims that might arise from this definition, where groups that have not lived in Canada might hold constitutionally protected title in Canadian lands. And the fundamental mobility right, which that includes, is incompatible, in our opinion, with Canadian sovereignty. And as a result, there are problematic consequences of a decision. And that is why, in the cases of Vanderpeet, Mitchell, and Beckman, the court has emphasized that the idea behind reconciliation is within a nation. It has to do with the reconciliation of Aboriginal and non-Aboriginal peoples within a shared society. And in fact, in the case of Vanderpeet, there's already reference to Section 35 rights as rights held, and I quote, only by Aboriginal members of Canadian society. Similarly, in the case of Mitchell at 132, the court explicitly says that Aboriginal rights are exercised as group rights in the 21st century by modern Canadians who wish to preserve and protect their Aboriginal identity. Clearly,
if we're talking about reconciliation, reconciliation is meant to assist in righting the wrongs of what the government has done to Indigenous people since Confederation, essentially, and what was done pre-Confederation as well. That would take into account what had happened to the Senate people. So reconciliation encompasses all of those harms that happened in Canada, within Canada's borders, during that process of colonization. So therefore, should we not be more flexible in approaching and accepting the fact that we have a responsibility to people even outside of our borders because of what has happened? And that all supports and goes part and parcel with reconciliation itself.
Absolutely, Justice. And I understand your concern that there is a broader implication for the historic injustices that have been done to the Sinaiticus people. But unfortunately, as we found in the case of the Queen and Blaze, the court is not free to invent new obligations that are foreign to the original purpose of the provision at issue. And as our position is that the original purpose is that reconciliation within society, it cannot, the principles of constitutional interpretation cannot allow this court to extend that interpretation and stretch it beyond its original purpose. I'd like to
stick in here for a moment. I sort of take it personally because I was one of the counsel in the Mitchell case. And because I am Haudenosaunee and my partner and my children are Mohawk, what Justice Binney did is take a treaty relationship that talks about two societies at a respectful distance from each other, not interfering in each other's path. That's the parallel ship and canoe. And he built unilaterally the concept into its opposite, which is everybody being subsumed into a shared sovereignty. But isn't that shared sovereignty, because you are saying Canadian sovereignty comes first, isn't that shared sovereignty assimilation, pure and simple?
Respectfully, Justice, it is. I see my time has elapsed. If I may briefly answer your question and conclude that permissible.
Please do.
Thank you. Justice, I absolutely understand your concerns in terms of assimilation, but it is our position that in order to move forward, Aboriginal peoples of Canada must be partners in sovereignty and that they must be given a voice in that sense. Because as it says at paragraph 73 of Gladstone, distinctive Aboriginal societies exist within and are part of a broader social, political, and economic community. And it is this broader context that creates the concept in Gladstone that limits placed on Section 35 rights are equally a necessary part of this reconciliation process. It is our position that the limit that we are asking the court to place today on Section 35 is a necessary part on reconciliation in order to protect those Aboriginal peoples who today live in Canada. Barring any further questions, this concludes the first submission on behalf of the respondent. My colleague will now address the second submission. Thank you.
May I proceed? Good afternoon, Justices. My name is Lesha Shah, and I will be concluding the final submission on behalf of the appellant, Her Majesty the Queen in right of British Columbia in the case at bar. It is our position that the majority erred in their application of the Vanderpeet test. The test comes from the 1996 Supreme Court of Canada decision of the Crown in Vanderpeet. There are 3 stages to this test. The first stage is to characterize the right claimed in light of the pleadings and evidence. The second stage is whether the right is integral to the distinctive culture. And the final stage is whether the modern right is a continuation of an ancient right. We are concerned with the final 2 stages of the test. We take the position that there has been a legal error in the application of the facts, and the evidence presented by the majority is insufficient to meet the test. The majority stated that connection to the land was still present in the minds of the members of the Lakes tribe. However, this is not sufficient to constitute as evidence of continuity and is not evidence as properly cognizable by the courts. Further, the majority—
Hey, counsel, I'm gonna challenge you there a little bit. What evidence would be sufficient then?
Justice, that would be—
You're saying the evidence was not sufficient.
Yes, and what would be sufficient is practice of the right that is being claimed on the ancestral territory of the Sinaites. And we are not contesting that the ceremonial purpose of the right claimed for hunting is integral to the distinctive culture. However, the Supreme Court of Canada disregarded the body of jurisprudence of the Supreme Court of Canada, which interprets the Vanderpeet test as a right to hunt is site-specific and on a particular tract of land bearing a geographical limitation on hunting rights, and is not an abstract right exercisable anywhere. In fact, the majority in assessing the integrality of this practice, the Mohawks—
I'm sorry, was there an argument that Mr. Desautel wanted to exercise this right anywhere, or was it not tied to a specific geographic region?
It was tied to his ancestral territory, Justice. And because he is requesting a site-specific right to hunt, geography is a relevant factor. In fact, in the case of Adams, the court consistently tied the claimed right to a specific area at issue, the region of Lake St. Francis. And once again, in the case of Cote, similarly emphasized that is the exercise of the claimed right on a specific geographical area that must be integral. And
Can I
that—
ask you a question here? I'm sorry. If I claim a right, for example, to use my Haudenosaunee name and not my English name, that's not site-specific. Are you saying, therefore, it can't be an Aboriginal right?
Allow me to clarify, Justice. Geographical considerations are relevant to the determination of activities which are integral in some cases where the activity is intrinsically linked to a particular tract of land. And so in the case of hunting, geography is a relevant factor.
So
Now—
if being cynicked is linked to ancestral territory and all the ancestral territory, then he's okay? He's site-specific enough?
No, Justice, because Mr. Desautel is requesting a site-specific right to hunt on his ancestral territory, which is now within BC, he must show practice of practicing hunting on this particular tract of land for it to show integrality as well as continuity.
Counsel, your colleague has indicated that this is a communal right, and that there was and you've indicated that there was some sort of error here. So I'm going through the trial level decision, and from paragraph 115 onwards, there's quite a bit of evidence from a communal perspective of this practice occurring with a specific interest to that specific geographic piece of land. So where is the error that is that we're supposed to overturn here today?
The error, Justice, was that the evidence presented of hunting was in Washington and not on the tract of land within British Columbia, where Mr. Desautel, as a member of the Lakes tribe, is asserting a right. And so geography, once again, is a relevant factor.
Well, I disagree with you there, counsel, because as you go on in the decision, the trial level judge actually did suggest, for example, paragraph 128, that even after 1930, hunting probably did occur just under the radar. And so where is the error that we're supposed to find here in this decision?
Justice, we have not found any evidence that past 1930, there was any practice on this land. And an 80-year temporal gap is not reasonable to constitute continuity, and definitely not for integrality. Because
again, if we can go back to the honor of the crown principle, the BC government made it illegal for these people to be able to do that in the first place. So how can you maintain both the honor of the crown and hold that breaks the continuity, in essence, actions by the crown? And not only that, but also the international border that was created, both without any consultation. So how are they consistent, honor of the crown and the interpretation that the appellant wishes this court to take in this case?
the honor of the crown, while perhaps not enacted when imposing this boundary, we are deeply sympathetic to this, as we acknowledge that this is a barrier for the Indigenous communities that have been displaced to practice on their ancestral territory. However, even after the imposition of the border in 1846 and the imposition of the Games Protection Act in 1896, there were still instances where the Indigenous peoples residing in Washington traveled up to their ancestral territory in BC and practiced on that land. And so while this may not be favorable, there are still other methods, legal methods, which the Lakes Tribe can demonstrate numerous interventions, I would submit, as the appellant would submit, to show that this is in fact integral. This could include petitioning the government or some kind of request, as well as applying for citizenship or residency, which would—
Counsel, let me ask you something. You are not, I don't think you're going to convince me that you meet the Van der Peet test, okay? Do you agree with the Van der Peet test? And should this court consider altering it?
Absolutely, Justice. Our position is that the Van der Peet test has not been fulfilled. And the interpretation that has been taken by the Supreme Court of Canada on numerous occasions, imposing the site-specific requirement, which was not outlined in Van der Peet because it was not relevant to the geographical factor.
You're telling me it hasn't been fulfilled. I'm saying I think it has. I'm asking you if this court should rewrite this test.
Justice, it is not a matter of rewriting the test, but looking at the interpretation in other instances where differ from the Van der Peet test, in that case, have imposed this requirement. In the Van der Peet test, geography was not a relevant factor because it fell on the opposite end of the spectrum for a site-specific right, such as hunting, because general trading rights lack an inherent connection to a particular tract of land. And so the interpretation of the test we submit should be upheld by this court. And even if this court were to uphold the Van der Peet test as it was originally stated, there are deleterious implications to such a finding. Finding that groups can claim a right to land which they do not reside within and do not actively practice on could very well dilute the already limited rights Aboriginal groups residing within Canada possess. And this could very well result in tensions between these groups. And this is not a hypothetical. In what is now British Columbia, there are numerous—
Counsel, I'm just going to interrupt you for a second because I don't think you really answered Justice Goodman's question, and I'm interested to hear the answer. Do you agree with the Van der Peet test?
We agree with the way that the continuity and integrality elements have been held up by the Supreme Court of Canada in the cases pertaining to rights, pertaining to a tract of land. So yes, we do agree with that interpretation of the Van der Peet test, Justice.
And you agree with the test itself, despite the fact that Justice Goodman has just indicated, and it would be suggestive of some of the other comments you heard from other justices today, that they believe the test has been met in this case.
In that case, Justice, we would not agree with the test, and that the test for rights pertaining to that are intrinsically linked to particular tracts of land should be altered to impose a site-specific requirement, because there are other implications to it, especially when it is pertaining to limited resources such as hunting. Extending constitutional.
Counsel. So you're talking about site specific, right? So in those sites, in this previous case law, there has been no unilaterally imposed colonial border in those site specifics, generally speaking. What do you have to say to that?
If I'm understanding your question correctly, you're asking that in the cases which have imposed the site-specific requirement, they did not include the imposition of the border, correct?
A unilaterally imposed border.
Justice, they did include the unilaterally imposed border. These cases were less than a couple decades ago and are still relevant to this day. There are many implications to such a finding that without tangible evidence of practice on this land, that there can be a right claimed. The honor of the crown would also be implicated in this case.
But didn't the trial judge, I'll let you go ahead. I've already asked, so.
Okay, counsel, I just want to make a point. You know, when you had indicated that there were no challenges brought by the group that was living in Washington and no real efforts to make sure that their rights were asserted, I just want to remind you that it was illegal for First Nations people in Canada to hire lawyers until 1951, and we're not granted the right to vote, status Indians, until the 1960s. So when we talk about our ability to assert rights and how that affects continuity, how does that play into any sort of idea of reconciliation and flexibility in Section 35?
Justice, I'd like to answer your question in two parts. First, we recognize that there is an appropriate amount of flexibility that may be needed in cases such as the case at bar. However, such flexibility has its limits. And secondly, if I could refer your honors to the case of Cote, where paragraph 52, they explicitly consider the effects of colonialism for such an interpretation of Vanderpeet, and yet in a unanimous ruling, upheld the site-specific requirement for continuity as well as integrality. And we posit that this is still relevant today as it was then. Now, to address the honor of the crown, this would increase the crown's duty to consult. The majority's suggestion that Aboriginal peoples residing outside of Canada would be implicated to a lesser degree would create a two-tier consultation. Respectfully, justices, subjecting the voices of certain Aboriginal peoples to a lower class of value in their consultation would undermine the grand purpose of Section 35, which is reconciliation. This would do little in advancing reconciliation, and even if it were to be implicated to the same degree, this would impede upon sovereignty. Further, in the cases of rights pertaining to limited resources, such as hunting, extending constitutional protection, where those rights are held by Indigenous groups residing outside Canada, decreases the availability of these resources to Canadian Indigenous groups. The Crown should not be forced to justify infringement under the Sparrow framework in order to regulate hunting in the province by members of U.S. Indigenous groups, nor should the Crown be required to allocate priority to the rights.
Why is it, Counsel, why is it the role of the Crown to unilaterally say how Indigenous First Nation groups in BC or any province or territory in Canada would feel about sharing resources, sharing land rights? If the First Nations people also as a recognized sovereign nations that are part of this reconciliation process, it seems to me to be a bit paternal to say that the Crown is making the decision that First Nations people don't want to share resources.
Maybe I could ask that a little differently if I could. In most cases, the border passes through the territory of individual nations. We're not talking about US groups and Canadian groups. We're talking about one group of people who've been divided by the border. And in a situation like that, I'm struggling with why is it unfair to the people on one side of the river to have their rights shared and to give a say with other members of their nation in all their territory. It's like walking into somebody's house and saying, the people who live upstairs are now foreigners and they get no say, because it would be unfair to the people downstairs to consult with them about what happens to the house.
I see my time has nearly elapsed. May I briefly answer your question and conclude?
Yes.
There is good reason for the province to prefer the rights of its own residents, because as it is our position, as my colleague has outlined, Mr. Desautel and the members of the Lakes Tribe are not Aboriginal peoples of Canada. And so in allocating wildlife resources, the Crown, in our position, must give top priority to constitutionally protected Aboriginal rights, to those who are indisputably holders of constitutionally entrenched Aboriginal rights are entitled to expect that their rights will not be inappropriately diminished. This does not coincide with the grand purpose of Section 35 and does little to advance a true intention of reconciliation, which is to reconcile Aboriginal and non-Aboriginal Canadians in a mutually respectful long-term relationship. For these reasons, as well as my co-counsels, we ask this court to allow this appeal, enter a verdict of guilty, and remit the matter to trial judge for sentencing. Barring any further questions, this concludes the final submission on behalf of the appellant. Thank you.
Are our respondents prepared?
Yes, may I please the court?
When you're ready.
Good afternoon, Chief Justice and Justices of the Honorable Supreme Court of Lions Cup. My name is Firza Shabazz. I, along with my co-counsel, Lila Belzi, represent the respondent, Richard Lee Desautel. Justices, this case is about righting a historic injustice. The appellants have submitted that there are policy implications of allowing Mr. Desautel this right under Section 35. However, the burden of proof falls onto Indigenous groups. They need to meet the requirement of whether they are an Aboriginal groups of Canada by showing their ancestral relation, their connection to the land, as Mr. Desautel has. At issue is whether the respondent's claimed right to hunt for food, social, and ceremonial purposes exempts him from the provisions under which he was charged. The respondents will be presenting two issues today. I will be addressing the first issue, and my co-counsel will be addressing the second issue. The respondent respectfully requests that this court dismiss the appeal and answer the constitutional question in the affirmative. I will be making two submissions today. First, I will present the importance of Aboriginal perspective. Second, the importance of belonging in relation to the Aboriginal land. Beginning with my first submission, I submit that the purpose of Section 35 is to not only recognize and reaffirm Aboriginal rights, but it is also to reconcile. The proposed interpretation of Section 35 encompasses the modern-day successors of the Senex tribe, that which is Mr. Desautel. It's about recognizing that there was a prior occupation of the land before European contact that had their own way of living, that had their autonomous societies and their own system, in addition to reconcile the modern-day existence while maintaining Crown sovereignty over them. As was demonstrated in the Queen and Sparrow in the Supreme Court of Canada in 1990, that the interpretation of Section 35 is to be read in a liberal, generous manner that not only encompasses the perspective of the Crown, but the perspective of Aboriginal groups, specifically holding the Crown at a higher regard to take in the interest of Aboriginal groups. In Sparrow, the test for Section 35 was created to see whether there was an infringement of the right and if it was justified by the Crown.
Existing Aboriginal rights allows for flexibility with the rights over time. Recognized and affirmed means to highlight the appreciation of the history of their traditions and develop a relationship and to further the relationship with the Crown and Aboriginal groups. Both perspectives of the Crown and Aboriginal groups are required to further reconciliation. And I'd also like to turn your attention to the case law of Mitchell and Minister of National Revenue, paragraph 29, in which the purposes of Section 35 were laid out. It states that there were Indigenous groups prior to European contact who were here first, had their own way of living, their legal traditions, and to protect them from exploitation, as it is a fiduciary duty of the Crown. As well as in Manitoba Métis Federation and Canada, paragraph 30, it discusses a special relationship that arises from this colonial practice. And
Counsel, before we start talking about the fiduciary duty of the Crown and the relationships between the Crown and Indigenous people, shouldn't we affirm first that the Indigenous group in question is an Aboriginal people of Canada? Can you address the threshold question for me?
Right, thank you, Justice. So Mr. Desautel is an Aboriginal peoples of Canada under Section 35, as he has an ancestral connection to the land in BC, as he is a modern day successor of the Senex tribe. And in addition, it was demonstrated by Professor John Royals in Earthbound Indigenous Resurgence that even though Aboriginal groups have been removed from their physical ancestral land, they are still connected to the land in their hearts and in their minds, as well as their roots, their worldviews are implemented in their ancestral land.
Counsel, do you have any submissions to respond to your friends as it relates to the specific piece of land and any evidence about the specific piece of land in Canada?
Could you elaborate on that, Justice, please?
About the need for evidence as it relates to a specific piece of land, or alternatively, any deficiencies in the evidence on the record as it relates to the specific piece of land. This was the submissions that were made by your friends, and I'm hoping that you can make some submissions to that point.
Right, thank you, Justice. So it is important to understand that oral history, oral communication of how their legal traditions have been passed down and is really important and crucial in this case because we have different individuals, Mr. Desautel himself and individuals from the Colville Lake tribe that are explaining their ancestral connection to this land. And so my friend submitted, pardon me, moment's indulgence. Thank you. In accordance with what my friends have submitted, oral history, their oral communication is important because that was their only means of passing down their legal traditions and how they govern themselves. And this was established in Delgamuukw and the Queen, where oral history would be accepted by the courts. And it is sufficient of evidence to demonstrate that Mr. Desautel has an ancestral connection to the land in BC.
It's sufficient evidence if we give it enough weight and determine it's sufficient. But as you saw in the dissent, there was some concerns. I think you quoting, I think Justice Binney and Mitchell, that, I mean, we need to be a little careful to do that. Is there the right amount of evidence here for you to meet your burden?
We submit that there is, thank you, Justice, for your question, and we submit that there is the right amount of evidence to showcase that Mr. Desautel has this ancestral connection, as he and other Colville Lake member tribes explain that connection through moment's indulgence. They explain their connection to the land and how they felt when they were on the land and what it meant for them to be on the same grounds as their ancestors. Secondly, I submit Indigenous group like the Lakes Tribe's center focus are their ancestral connection to the land. In this situation, Mr. Desautel has that connection to the land. In accordance with the Royal Commission on Aboriginal Peoples, It was highlighted through the Aboriginal perspective that the identity of Aboriginals lies in the heart of their existence, and it's essential to groups living.
Okay, Counsel. I'm curious how you answer the appellant's concern, and although they didn't use the word floodgates, very much what I heard is a floodgates argument, that this could lead to a rash of claims coming from south of the border. I wonder if you might reassure us about that.
Right. Thank you, Justice. So if there is a floodgate of submissions after giving Mr. Desautel his right under Section 35, the burden of proof lies on Indigenous groups to prove their ancestral connection, as Mr. Desautel shows and other Colville Lake tribes have shown. And so it was highlighted through the Aboriginal perspective that the identity of Aboriginals lies in the heart of their existence, and it's essential, whether he may be living in America or he's living in Canada, that ancestral connection in their minds and in their hearts are important to them. The cultural identity is strictly related to the ancestral land. It provides for a sense of belonging, closeness to their families, and it allows them to be closer to their elders.
You've done something a little strange here, and for that matter, so have your counterparts. And I want to ask a question I'm having difficulty articulating. Where we are in Canada now is an Aboriginal right is a practice that is integral to your distinctive society. But we have two competing streams here. One is, if it's also a practice that's integral to every human society, then it's not cognizable, it's not an Aboriginal right. And if it's so different that it's not digestible by the common law, it's not acceptable either. So an Indigenous people has to show that it is comfortable to the common law, but yet very different from the common law at the same time, different from Canada. So really, isn't an Indigenous people boxed into a Canadian definition of what's comfortable for Canada?
Can you elaborate, please, Chief Justice?
Well, the question is, an Aboriginal right, according to some people in the Supreme Court of Canada, must be, and this is the Bernard and Marshall decision, must be cognizable, can't be so different from the common law that there's a disconnect. So if your legal system is really different, and this hearts and minds theory that you're putting forward isn't the same as Canadians, because Canadian society is essentially an immigrant society. So if you're putting forward something that's so different from the common law that there's a disconnect, then you can't claim an Aboriginal right in Canadian law. But if you claim something that's identical to the way Canadians are, then that's not different enough, and you can't claim it as an Aboriginal right. Haven't we catch-22'd Indigenous people?
So from what I understood, that if you're right, and I agree that if we're looking at Aboriginal rights from a Canadian perspective, then it adds, sorry, a moment of indulgence.
It's okay, I asked a tough question there.
Thank you, Justice. So it's important to look at the purpose of Section 35 is to not only recognize and reaffirm those rights, but it's to reconcile by adding the perspective of Aboriginal groups, that which is the main focus. How can we restore those rights? How could we mend those ties if we're not looking at what is important to Aboriginal groups? And I just want to refer to the trial judge's finding in paragraph 125, when Mr. Desautel was asked what it meant for him to hunt in BC and what it meant for him to be in the same land as his ancestors. He replied, "When I come up here, I'm walking with the ancestors and God. I just think about the times that they were going up the mountain like this here." As well as paragraph 125, and Michael Marchand, another member of the Colville Lake Tribe, states, "And we try, even though we can't go back in history and exactly duplicate those things today, we could try to go back to the best parts of our traditions and bring those into the future." So Arrow Lakes land is one of those. These are not only heart-moving statements, but they are the truth about their cultural identity. and what it means to be connected to their ancestral land and what it means for them to practice on that ancestral land. In conclusion, the issue at hand is modern day successors like Mr. Desautel have not given up their land or their cultural identity. Their roots are planted in Canadian soil, and to weed out one would mean the downfall for reconciliation. Respective Chief Justice and Justices, it's in the hands of this Honorable Supreme Court to, with the utmost regard to the Aboriginal perspective, plant the seeds for further reconciliation. Subject to any questions, these are the respondent submissions. Thank you.
Thank you, Counsel.
Thank you very much.
Is the respondent co-counsel prepared?
I am, thank you.
Okay, you may begin.
Good afternoon, Honorable Justices and Supreme Justice of the Honorable Supreme Court of Lions Cup. My name is Lila Belsey. In support of the respondent's position that the Supreme Court of Canada correctly held that the respondent, Mr. Richard Lee Desautel, satisfied the continuity element outlined in the Queen and Vanderpeet's decision at the Supreme Court in 1996, I will be making two submissions today. First, in regards to the potential issues arising from brief lapses in occupation and land use by the Sinixt tribe in British Columbia, and any ambiguity resulting from these gaps, the court must find in favor of Mr. Desautel. Second, the lapse in question is not a significant enough portion of time to negate the millennia that the Sinixt maintained their practices prior to European contact and following European contact, and to dispute that fact would ignore the Aboriginal perspective on the matter. I'd like to deviate a little bit from my planned order of proceedings so I can directly respond to something that my friends said. Initially, I believe my friends suggested that in allowing, in our interpretation, Mr. Desautel to claim a constitutionally protected right to hunt, we're ignoring the existence of international borders. Now, I would like to give us a little bit of background information so we can qualify that. The trial judge found in this case that the Sinixt people had a continuous occupation of this land, West Kootenay, under the name the Arrow Lakes Band, which is a sister group to the Lakes Colville tribe. And collectively, these Sinixt peoples follow this migrational hunting pattern from the historical northern half of their territory in what is now British Columbia to the historical southern half of their territory in what is now Washington State. Now, if my friends suggest that by claiming this Aboriginal right and affirming this Aboriginal right, we're ignoring international borders, the insistence that my friends made that the Vanderpeet test is going to include some kind of site-specific element towards the continuity element here, that I submit, in fact, would be ignoring international borders, as the international borders created at Confederation are a very big factor in fettering how these people were able to practice this migrational hunting pattern. The timing between the last incidents of hunting in 1930 and Mr. Desautel's hunting trip in 2010 doesn't constitute a rejection of this Aboriginal right. And to do so would have absolutely no precedent in the Supreme Court. The Supreme Court has never ruled before that you can abandon a constitutional right by disuse.
Counsel, can I just stop you for a second before you move on? What do you say is the intersection between international borders and Aboriginal rights from a policy perspective?
Pardon me, Justice Goldlist, are you asking me where?
How do you reconcile the clash?
How do I reconcile the class?
The clash between,
oh, absolutely.
Yes. How do you reconcile the clash between the argument about international borders and Aboriginal rights, which obviously transcend those borders, both historically, culturally, and legally in some instances?
So in order to reconcile in our minds and in the legal perspective, the matter of Aboriginal rights and the existence of these borders. It's very important, I submit, to recall that these borders, including the Oregon Boundary Treaty in 1846, that was a contributing factor to the fettering of the migrational hunting practice, was imposed across Indigenous territories with no consultation and no consent on behalf of the Indigenous peoples. So we have to be generous about that when we consider how this affects migrational hunting practices. Furthermore, there's also the enaction of the 1896 Game Act, that also contributed to this fettering of migrational hunting practices by directly outlawing the practice of hunting in British Columbia by Indigenous peoples. In addition to that, as was found by the trial judge through statements from the Lakes Coville tribe, at this time there were increasing instances of gun violence and death as a result of confrontation between Indigenous peoples and European settlers. So all of these factors are creating a dangerous environment for Aboriginal peoples and fettering their ability to practice this traditional hunting right.
Okay, Counsel, so I understand the notion of flexibility as it relates to the Vanderpeet test, and in particular with the continuity aspect. But is there any precedent to have the same type of flexibility as it relates to the threshold question in Section 35?
Pardon me, Justice. We're asking here in this case whether this flexibility that's outlined has to apply also to the threshold question in addition to the question of whether the respondent meets the Vanderpeet test. Is that what you're asking?
Yes.
Yes, I would submit in it to sum it up, yes, and to elaborate on that, the need for flexible interpretation of the threshold question of whether Mr. Desautel is considered an Aboriginal peoples of Canada has to also be interpreted flexibly if we consider the purposive intention of Section 35, which is to reconcile Aboriginal peoples with Canadian sovereignty. Now, considering these colonial incidences such as borders going up, moment's indulgence, if I may, considering these colonial boundaries, such as the Oregon Boundary Treaty, as well as the prohibitive laws of the Game Act, we're looking at a very colonial imposition upon Indigenous peoples, and especially in terms of when we're deciding if they are eligible under Section 35. And in order to consider the Indigenous perspective as is required by the concept of reconciliation, we have to understand that these laws and these borders occurred without the consent of the Indigenous peoples in question. And so we owe them that flexibility as well when we determine if they are subject to the protection of Section 35.
Here's a sort of a threshold question, because maybe you don't have any choice, and I apologize for how mean this is. If you adopt the Vanderpeet test, what you're saying is that the moment an Indigenous people meets a European, no matter how scruffy and no matter how isolated, that person gels that people's rights for all time. But if they meet an African, or if they meet a Quechua from South America, it has no effect on their rights. So isn't the very foundation of Canada's laws about Indigenous rights fundamentally racist? And how do you deal with that?
Thank you for your very thoughtful question, Chief Justice. In regards to the potential racism that you brought up here, I'm not necessarily submitting that an Indigenous personal interaction with a person of European descent or a person of color is going to be fundamentally different or going to be fundamentally covered by Canadian law. What I am submitting is that in the case of Indigenous interaction with the Crown, that is where we are owed this flexible interpretation and this fiduciary duty on behalf of the Crown to consider the well-being of Indigenous peoples.
Well, you're right when you're dealing with Aboriginal title. that the reconciliation is between the Crown saying it owns the place and people who are here first. But where we're talking about Aboriginal rights, it's the first scruffy European you run into, no matter what nationality. In the Mitchell case, it was Sam de Champlain shooting 3 Mohawk chiefs, the bullet to the head school of first contact. So my question is, at some point, do we break from the fundamental racism of the Canadian legal system? Do we even recognize that it is?
I would like to respond to that, but I am a little bit. I would request a little bit of clarity on your part. Are you referring to contact between Indigenous peoples and say the as you say the first scruffy European, as in like this is the point of European contact that we need to consider when we're looking at the Van der Peek test? Is that what you're referring to, Chief Justice?
That's what I'm saying. Europeans are special. They gel your rights for all time. Other people aren't special. They don't have any impact on your rights. How do we deal with that? Is it time to go?
Pardon me. That does pose
you replace it.
That does pose a very interesting question, Chief Justice. When we look at, to answer that question, we have to look at the history of colonialization of North America. That colonialization primarily occurred by Europeans, which is why we take our Canadian legal system from the British tradition. This can absolutely have implications of racism. However, I think in this particular instance, the colonial perspective that's being imposed on the Indigenous peoples of Canada is a European one, and for better or worse, that is what we have to act under at this time. I'm not suggesting that this imposition is necessarily morally right. However, it is what we have to act under as Canadian citizens and Aboriginal peoples of Canada. If I could move on to my second submission, in regards to the 80 years between the last instance of hunting by the Lakes Coville and Mr. Desautel's hunting trip, I submit that this 80 years is insignificant in comparison with the Sinaics tradition that existed for millennia prior to European contact, and likely would have continued to do so had Europeans not imposed these colonial boundaries upon them.
Counsel, your friend suggested that there were avenues in which Mr. Desautel or the generation before him could have asserted their rights and maintained a level of continuity. Can you respond to that in terms of their ability or inability to be able to maintain that connection?
Absolutely. Thank you for the question, Justice. In this case, I would argue, I would submit rather that the Lakes Coville tribe individuals, as well as Mr. Desautel, did practice continuity of this hunting practice. Now, the practice was traditionally migrational, as I've established prior, and this imposition of an international border does better that migration. However, the Lakes Coville tribe does continue to practice hunting traditionally in their land in the southern half of their traditional territory. Now, to answer the second part of your question in terms of whether there is something that continuously ceases them from trying to practice this right, I would actually turn you back to the claim that you made earlier that Indigenous peoples were not allowed to hire lawyers until 1951, I believe. And in that case, we recognize that this is a big legal undertaking on the part of the Lakes Coville tribe. And so if there is not an explicit provision in the Constitution set out until 1982, there is, pardon me, if I could have a moment's indulgence while I just collect my thoughts on this matter. So yeah, I would submit that there is a little bit of continuous fettering, not a little bit, a substantial amount of continuous fettering on behalf of the legal regulations around whether Mr. Desautel and other members of the Lakes Coville tribe are able or not able to continuously practice this migrational territory. or
I have a
pardon me,
question.
migrational hunting.
I have a question. So in terms of how you would consider site-specific, can that encompass an entire migratory path in terms of that space between as you migrate from the US to Canada as being site-specific in and of itself? Or would you interpret that as being site-specific as in where they end up and then start hunting and not including the path that they took to get there? And if you would say that, do you believe that the test should be changed at all in terms of how site-specific is posed?
I see that I am rapidly running out of time. Justice, may I answer your question and then I will conclude very quickly, please? Thank you. In terms of this element of site specificity, it's not part of the Vanderpeet test at all. There's nothing in the Vanderpeet test that says that this practice needs to be site specific, and I don't submit that it needs to be either. The continuity of the traditional practice has to be there, but there's nothing in the provision that says that that needs to be site specific. So I would disagree with my friend's submission on that point. To conclude, a ruling that continuity is not upheld would be heavily influenced by colonial perspectives and not with the fair due that Section 35 requires Aboriginal peoples in the spirit of reconciliation. And therefore, Mr. Desautel must be found to meet the requirements of the Vanderpeet test and be entitled to practice his Aboriginal right and to continue to uphold this sacred tradition that his tribe has upheld for millennia. To conclude, the respondent respectfully suggests or requests that this court dismiss the appeal and answer the constitutional question in the affirmative. Subject to any questions, those are the respondent submissions.
Thank you, counsel.
I am no longer muted. Thank you very much, all of you. Forcing us to ask difficult questions has been an education for me, certainly personally. And it's been a great pleasure to hear all four of you. This is going to be a very difficult decision.
Thank you so much. We can stop the recording now.
Actually, we're not going to stop the stream for a second, just the stream, just in case, because I know Naomi's streaming, because I know a lot of the competitors are watching via the stream and the spectators are watching via the stream. So I'm going to assume that in about 10 to 15 minutes maximum, the link will open. Based on the link that we were using all day today. We ask all the competitors to join on that for the awards ceremony and to announce the winners of the 2021 Lions Cup. At this time, I'm going to end the recording. I'm going to ask Naomi to end